welcome to another episode of Unscripted. Brian Levine, how are you today? Thanks very
I,
much for joining.
I'm good. How are you?
I'm so excited. This is the second time we went overtime last time, and I'm so much appreciative of you providing some of your precious time to let the viewers dabble into M&A and cybersecurity and compliance. Why don't we discuss some of the things where we left off? And just to start with, if you recall, we discussed the kind of the challenges associated with doing M&A, specifically around evaluation of cybersecurity and compliance controls for that entity. Let's start with kind of a broader question. How do you start the process in terms of discovering like the crown jewels, in terms of data privacy? It seems like when you get into an engagement, there's got to be some sort of step-by-step process you follow. If you don't mind just following through, that'd be very much appreciated.
Yeah, well, interestingly, when it comes to cyber assessment in the context of diligence and in the context of M&A, it's probably less of a set process than cybersecurity professionals would be used to, because every deal is different and the specifics of the deal are going to dictate the level of access we get, when that access occurs, and what it looks like. And the process has to be flexible to meet the realities of the deal. Sometimes we have a lot of access, sometimes we have very little. The first thing is to understand really how important the cybersecurity question is for the particular deal. Sometimes you have clients that it's very important to, and you agree because the target is very risky. Other times, the client's maybe making a 20% minority investment in a company. It's a small one for the client. And even if it turns out that the cybersecurity of the target is relatively weak, they're still going to go through with it, and they're not going to have much ability to influence it. And so part of it is really listening to your client and understanding your client's investment thesis. But there's essentially three ways to go about getting information from the target, depending on the circumstances. One is inside out, is what we call it, when we are asking them questions directly, hopefully with somebody who knows about the cybersecurity of the target. Because the other problem you have to deal with is that not everybody is read into these transactions on the seller side. Sometimes it's only the CEO and a couple of top people who know about the transaction, and the person who knows about cybersecurity might not be one of them. And you'll be surprised to learn how little some CEOs know about the security of their own company. So you're asking questions, hopefully to someone who knows the answer. You're asking for documents, hopefully from someone who can provide those documents, and you're reviewing those. And that's the inside out. Outside in, you're certainly able to tell some things about a company's cybersecurity and data privacy from the outside in. For example, they have a website that's going to give you some information. You can do open source intelligence. You can do dark web research. We have the ability to see whether the company's IP address range is currently communicating with a known threat vector, like a command and control server or a botnet. So we try and figure out as much as we can from the outside in so that we don't have to interfere too much with the deal. And then there's the most invasive option of the three, which is technical testing, which is becoming an increasingly common part of every deal, where we do things like compromise assessments or pen tests or code scans to really understand, is the target compromised? Are there any vulnerabilities that need to be resolved? And what is the buyer really getting themselves into?
I love this answer just because it shows the level of complexity involved, and more so the level of importance for your expertise, specifically in your guidance. Because again, you come into a transaction, and I believe there's a lot of reliance on you and your experience to which approach is best and which approach will lead to less friction, but more results oriented. And then I guess less investment from all sides involved. And that leads me to the kind of the question is, do you often get resistance from from the interested parties in terms of providing the? I'm assuming that every security professional, especially the one responsible, a lot of times they have this protective approach to say, okay, my infrastructure is secure, my teammates are all fabulous. We rarely see any type of activity, so on and so on, and it's understandable. How do you then maybe find out what's not said?
Yeah.
Read between the lines.
No, that's a great question. It's an unusual environment because normally when you're doing an assessment, the person you're doing the assessment for hired you to do that assessment. So they're very cooperative and they really want to give you the best information and do it timely because they want the results as soon as possible. Whereas here, you're assessing a company that really doesn't want you to assess them. There's a couple of takeaways from that. The first is you're going to have to deal with a certain amount of ambiguity. You're never going to have perfect information in the context of a transaction, in my experience. At least early on, you're not going to. And security people hate that. Security people hate having any ambiguity. They like knowing specifically down to the technical details.
Down to the zeros and ones.
Down to zeros and ones, exactly, the binary. You want to know down to the zeros and ones, and you're not going to get that. So you're going to have to infer things from what's being said to you, how it's being said to you, what you can learn from the outside in, what you can learn from any technical testing. And it's helpful to come in from the right perspective and to help the target understand the perspective you're coming from, which is, the way I look at it is, my client wants to do the deal or they wouldn't have hired us. They want to do the deal. So it's not about us evaluating and giving an A, B, C, D, or F to this company. We're not evaluating. We're just trying to understand where they are on the cybersecurity journey so that the client can just take that information into consideration when figuring out what they're going to do and make plans. If we can help the target understand that this is not about grading them, it's just understanding where they are so that the client has more certainty. Because in my experience, cybersecurity, I think you made this point last time, doesn't typically derail a deal. They're probably going to go through with the deal. They just want to know as much about the target before they sign on the dotted line as possible so that they can literally say they have done their due diligence. So there's no right or wrong answer to these questions. If they don't have a particular system in place, they don't have endpoint detection and response, all right, fine. They'll get it. Once they're acquired, they'll get it in place at some point. It's just understanding what's there and what isn't and what are they doing and what are they not doing.
In industries moving from a point-in-time snapshot in a lot of different areas to a continuous process. Because due to the fact that a point in time has very limited value, really, because again, you assess organization and a week later, literally a week later, even hours later, things can look very different. In your world, how does that translate? Do you do any kind of, continuous anything, or is it always a point in time?
That's a great question. In general, diligence is a point in time because it's a very fast-moving process. Our standard diligence is 2 to 3 weeks. So most of it is really point in time. When we do a compromise assessment, we typically want to look for 4 weeks because criminal threats sometimes take some time to emerge. For example, had we been monitoring a company that had the wrong version of SolarWinds in place, it likely would have taken us 13 to 16 days from the time that version was uploaded to see anything that would have been unusual. So we want to have enough dwell time in a compromise assessment to see that kind of thing. Then we also typically recommend, given that in diligence, you're always going to get restricted access and you're never going to have as much time or cooperation as you necessarily would like, that there be a second assessment later on before there's any integration, before you get too far after close, which we sometimes call confirmatory diligence, where we go into more detail. So that's the second point of time. And then we don't advertise this because so far it hasn't come up. But when we do that outside in where we're seeing if the target's IP address is communicating with a known threat vector, we do actually leave that on. If a year later they start communicating with a known threat vector and that acquisition went through, we would likely call our client and tell them that. It hasn't happened yet, so I don't know. But you're right, it's mostly a point in time thing. Security, as you said, is not a point in time, it's a continual thing. But one of the things we do during diligence is we'll ask them, what is their roadmap? What are they planning to do in security going forward? Do they have any open positions? Are they planning to hire? And as much detail, if they have a written plan, we like to get as much detail as we can. Of course, the acquirers recognize that anyone can make a roadmap. It doesn't necessarily mean that actually would happen or that they have budget to do it or that they have interest to do it. But it at least shows that they've thought through their strengths and opportunities and have started planning to meet those opportunities.
Yeah, absolutely. And Brian, what's interesting is that you have a unique position to answer the following question, which I think will be very topical to a lot of companies. So let's assume you are a founder of a startup. And you know where I'm going with this because you're very sharp. So you're a founder of a startup, you're 5 years in, you know that you raised 2 rounds, 3 rounds, you're in the process of shopping around for buyers or potentially to merge. What would you do to be attractive and streamlined? Just like security is a process, has to be integrated into like software development, into the operational fabric of a company. It's the wrong thing to do to kind of figure out all of a sudden 2 months before that you're trying to get acquired to start putting everything in place. So what would you recommend for, these executives to go through so they don't have to scramble, so they have all their ducks in a row, so they're attractive for an acquisition?
Yeah, no, that's a great question. So there's something called the sell-side cyber diligence. Many people haven't heard of it, and I know that because we did a webinar once on the topic and did a polling question, and most people hadn't heard of it. So essentially what sell-side diligence is in general is, you're going to sell your company at some point. Maybe it's a couple years down the road, maybe it's a couple months down the road, maybe you just don't know when it's going to be. So you hire a bunch of advisors, typically who do a lot of the same thing on the buy side, to advise you on how you can position yourself best to do well in that sell side process. And that can involve everything from helping you build up your program to make it look and be appropriate from a cybersecurity standpoint in the cyber context, to actually helping you in the process of the sale. We do a lot of this, and some of it I liken to staging a house for sale, because I am someone who fell for a staged house. I bought this lovely little house in Bethesda, Maryland, and it looked pretty big when we were in it, but it turns out they had staged it with dollhouse furniture, and we found out afterwards when we tried to move our furniture in that their furniture was very small. Now, luckily, you haven't met me in person, but my wife and I are also dollhouse sized, so it turned out to be okay for us. But from that, I learned that staging can really make a big difference. Part of what we do when we do sell side is actually improve the cybersecurity of the organization in a way that makes sense. So you can spend a lot of money on cybersecurity, or there's probably 20 or 30 things you could do that will dramatically improve your cybersecurity and the optics around your cybersecurity that is very inexpensive. Things like policies, for example. If you have no policies, you have one policy, that's not going to be super impressive to a potential buyer. But it doesn't cost anything to make a policy. You just have to do it. And then you have to put it into effect. Just having a policy just written is not super helpful if nobody's actually following it. And a buyer will figure that out in diligence. But I think I mentioned last time, we have reduced the acquisition price when we do buy-side cyber diligence by $1.2 billion. And so just based on cybersecurity concerns alone. And so you don't want to have that happen to you. If you started a company, you want to get as much for it as possible. You don't want little things like cybersecurity concerns or other things that aren't even related to the core business of the company to dramatically reduce the value of the company when you go to sell it. The other thing that happens is sometimes the exit is IPO. And so in that case, it's somewhat similar. We do what we call IPO readiness from a cybersecurity perspective to get companies ready for IPO, because in both of these instances, you don't only have to worry about the bad guys who are going to be attracted to the situation and the possibility that the price you get for the company could be impacted by security. But especially in the IPO situation, you suddenly have new regulators that are very interested in you and that expect more from you than 5 days before your IPO. So you have to start considering that as well.
Yeah, and it's interesting you mentioned IPOs, because I've noticed that sometimes in the process of going IPO, the company gets acquired.
Mm-hmm.
And I think some of the reason is, again, because of the due diligence that's been done and having all the ducks in a row, the company's then becoming more attractive for that buyer. And maybe some other reason, maybe they don't want to pay more once it goes to IPO. But I think that there's something to be said about having the mechanism of cleaning house, so to speak, and becoming more hygienic to being attractive to a buyer. And thank you for that story. I think people will remember that for sure. Yeah, let me ask you this. You mentioned a couple of cases, right, where, things were not as they seem, and you had to maybe have difficult conversations with the defenders, the CEOs, executive, and so on. Maybe there's another story you can provide and mention in terms of something that's memorable. Maybe something in terms of some unethical procedures or process or something that happened. And again, without mentioning any names, but these are the cool things that you encounter that a lot of people don't have a preview to.
Yeah, you would be surprised, or at least I was surprised at some of the stuff that goes on when the people are trying to sell companies, and or when you have smaller companies that don't really have great attorneys, either through the process or before. I'll give you a couple examples. We did diligence on a company relatively recently where they told us that they had a particular EDR in place, endpoint detection and response software in place on all their endpoints, which was a good one. And we felt very good about that. So we gave them credit for that in our diligence. And then afterwards, when we finished the diligence phase, the acquirer had already signed. We went to do a compromise assessment on them. And as part of that, we were going to use their EDR. And that's when they told us for the first time, oh, we actually don't have that EDR. I said, wait, you said you did have the EDR. They said, well, that was actually a trial version. So they didn't have it. You can't count a trial version. That's not having an EDR. That's having...
Right.
Go ahead.
We should have a 30-second moment of silence for let that to sink in.
Yeah, let that sink in. A trial version is not having the thing. It's like saying when those services offer a 2-month trial version, I just have all these offers here. That's having it. That's not having it. That's a preview. That's one element. Another one, when we went to do the compromise assessment after the diligence, we found out that they had an active ransomware infection that was present during the diligence, but they somehow forgot to mention when we asked them that question. So that's actually fraud. Both are fraud. One is a more clear-cut case than the other one, but both are fraud. It's illegal. It could potentially even be criminal to do that in a diligence and in the context of a transaction. So I don't want anyone to think that because a couple of people have done these kinds of things, that's okay. But I think it happens fairly regularly, which is why you need competent advisors, independent advisors to go in and really find out the truth. One other example I'll give you, we noticed on a particular company's website that it said that they were high trust certified. But when we got actually the information from them and did our own research, we couldn't find any evidence that they were actually high trust certified. And so we asked them that on the diligence call. We said, we saw on your website, you say you're high trust certified. It doesn't seem like you are. Can you help us there? And their answer was, that's just marketing. Just marketing. Yeah, I'm going to let that one sink in, because I was thinking to myself, to the courts and to the regulators and to your customers and to high trust, it's really not just marketing. And they're not going to be okay with that. But they really didn't seem to think it was a big deal. They thought that it's aspirational. We're someday. And I'm like, someday I'm going to win the Olympics. So I'm just going to put on my website 4-time gold medal winner of the Olympics. Because someday, you never know.
I'd love to be the fly on the wall having this discussions with some of these folks, and just to be there in the same room and talking about what is the reaction associated. And you mentioned, and it's really interesting, you mentioned it, that some of them think that it wasn't a big deal.
Yeah.
That there's one thing to purposely know that you're committing a fraud, and it's a completely different thing. Even though in the eyes of the law, not knowing does not exclude you from punishment.
It depends on the context. Certain crimes do require you to know that what you're saying is false. There's some times where there is strict liability. But yeah, no, it's depending on what the thing is. And I'm not going to refer specifically to any of those 3 examples, but sometimes we have to explain to business people, whether they're on the target side or the client side, why something is a big deal. And that's important, because when you're doing transaction diligence, or when you're working on transactions in general, you're mostly working with business people, not cyber people, not data privacy people. You're hopefully getting facts from them. But when you're reporting back out on either side, you're mostly talking to the C-suite or corp dev, and you're talking to more strategic people. So you have to be able to explain to them why this is a big deal or isn't a big deal, and how big a deal it is. Because the challenge is, the whole transaction is about risk, right? The buyer is taking a very risky bet in every instance that they're going to spend millions or sometimes billions of dollars for a particular company, and that's going to pay off in the end, and as opposed to just being a waste of millions or billions of dollars. So they're already taking an enormous risk. And so from their perspective, like, how does this cyber piece add on to that? Is it a trivial addition to the other risk, or might it undo the value of the whole transaction? And that's what we're trying to help them understand.
In speaking of breach and notification and so on, do you ever consider how it's always a matter of when, not if, right? So do you ever consider how the company responded or advertised that they got breached? Is that ever something that's considered? And then the second piece, the follow-up question is, you are in a position to answer this really well as well. What would you recommend the right thing to do when something like that occurs?
Yeah. So we're always looking at that, because most companies, most acquirers are not going to penalize you too heavily for having a cyber incident, because if they did, they'd have no companies to acquire, because cyber incidents have happened to most companies that have been around for a while. So the best thing one can do, I think, is understand how they responded to it, not dwell on the fact that they had it. When we think about how they responded to it, some of the questions one has to understand is, first of all, what kind of lingering exposure is there? And do they know the answer to that question? Hopefully they've done enough to educate themselves. A lot of times we'll ask about their previous incidents, and they'll say, no, we didn't speak to a lawyer about that, either inside or outside the company. But we don't think it's a big deal. Right. Now, we don't know if there's lingering exposure because they didn't assess that at the time themselves.
Can you Brian, do you mind for the audience to define lingering
Lingering
exposure?
exposure. All right. So if you have a incident, let's call it a PII data breach or data spillage, where you sent protected health information about 50 patients to the wrong insurance company. Say that, for example. But that was the first time it's happened. You didn't consult with a lawyer inside or outside. So you didn't do anything other than maybe update your process a little bit or tell the insurance company to destroy those documents. You don't know whether you have, quote, lingering exposure, which is my own phrase. I don't think lingering is necessarily a defined term of art. But what I mean there is, were you required by any regulation to disclose that to either the affected patients, to a state attorney general, to the Department of Health and Human Services, or to some other party? Your insurance company even. Did you disclose it to your insurance company? Were the individuals impacted by it, damaged in some way such that they could bring a class action or some kind of other litigation against you? So when I say exposure, I mean that you may end up having to pay money as a result of this incident, whether that's a fine, a penalty, litigation costs, etc., or might have a reputational hit come out as a result of it that you haven't already taken. That's what I mean by lingering exposure.
And lingering, from a timeline perspective, it can happen almost years afterwards, right? Some of this stuff can pop up.
Yeah. So statute of limitations are often based on or begin at discovery, or at the time a victim could reasonably discover that this happened. So if the company has an incident and they've never disclosed it, and it doesn't come out that they had the incident for 2 years from the time of the incident, that is often when the statute of limitations begins to run, from 2 years from the time that they could reasonably have discovered the incident. Yeah, it could be years later. So the first question is lingering exposure. Second question is, how did they respond to the actual breach? One of the things I'm looking for there is, are we certain that they're not still breached? Because as we know in the industry, if you have an incident, it's pretty hard to determine the scope of the incident and if the bad guys created a back door or whether they're still in the systems. Did they do enough to determine that they're clean now? If not, then we're going to encourage the acquirer to determine them for themselves before they get too deep into the transaction whether they're clean. And then the third piece is the remediation. And did they do the appropriate steps to remediate? But one of the things I'm very focused on is, did they just narrowly close the one vulnerability or the one gap that led to the issue? Or did they think about it more holistically, for example, and bring in a third party to assess their cyber program overall? Or did they think about, how did they end up with that vulnerability? What about their patching process or whatever led to that vulnerability being in place for so long?
It sounds like you can do a lot as a company to minimize the impact of a breach by taking the right steps at that time of the incident.
Yeah. And I'm glad you mentioned that, because your other question was about what should companies do. And some studies that have come out recently have suggested that companies that are well prepared for a security incident end up spending something like, or end up losing something like 50% less than companies that are not well prepared, which was a surprise to me. I thought it would have made some financial difference, but I wouldn't have said it was half. That seems like a lot, but that's what the studies show. And so I think having a well-planned program to respond to incidents is super important. And what I would include in that, this isn't an all-inclusive list, but one, having a good incident response plan that ideally you've worked with a third party to really develop. It's not something you've printed off ChatGPT. Some real time went into it. Having incident response playbooks, which are incident response plans that have been catered to very particular scenarios like ransomware or third-party vendor breach or insider theft or data breach. So you have a specific flowchart or plan for each of those scenarios. And then having at least annual tabletop exercises where you bring in a third party, they actually test the plan with a realistic tabletop exercise. You take the learnings from that, you have an after action report, and you update your incident response plan and your playbooks based on what you've learned. And you've got to keep these things up to date. One of the things we see is that one of the most important parts of these plans, of course, is just contact information for everybody. And you break out your plan after having put it together 2 years ago, and half of the people listed there don't work for the firms that they did at the time that you put it together. So you're reaching out to some lawyer who isn't there anymore. You're reaching out to some forensic person who isn't there anymore. So keeping those things up to date, which the tabletop exercise can help with, is really important. And then I just always have to emphasize the importance of having a breach counsel involved in all these things that you can consult with, whether it's inside the firm or outside the firm, but someone who specializes in this particular area for every incident, because almost on a daily basis, there's new regulations coming out, new deadlines for disclosure, new interpretations of those requirements. The SEC rules just came out. Each state is passing their own data privacy law, and each one is coming into effect at different times. The chances are that you personally, if you're the CEO or you're the CISO, know all these requirements and are going to get it right is pretty low. Now, if you reach out to your counsel and they get it wrong, then you have a pretty good defense. If you reach out to a breach counsel and they get it wrong. These are some of the steps I would take to prepare.
Brian, you pack so much. Like, I'm trying to have my thoughts in order so I can dig into further more. But let me just make one statement that I think it's clear here. There's a couple, actually two. Is one, it sounds like the mechanics of the response to a breach is just as important as how. As you mentioned, just finding out who to contact and having that in place is very valuable. The second thing is the double click on it. The 50%, those are 50% of very large numbers. Yes. So even though you may sound like you have to make an investment in doing all the above, which you described, which some of it may or may not sound trivial, but it's not, it will pay dividends down the road in terms of how it's affect the company.
Yeah, no, I think that's absolutely right. You do have to make the investment up front, but look, NIST, one of the 4 or 5 major domains is response. Everybody agrees that the response is really important, and some think it's the most important thing because they know you're gonna sometime the bad guys are gonna get in. You're going to have incidents. If you're in business long enough, as whoever's credited with saying it, the companies who know they've been breached and those that don't know they've been breached, but they've all had cyber incidents at some point. You know what I used to say? I wanted to have a different version of that quote. So I used to say they're the companies that have been breached, and the companies that are not worth breaching. And so if you can be in one of those two categories, you'd rather be in the breached category. Because if you're not worth breaching, if the bad guys are thinking, I breached this guy, but they have no money, they have no clients, they have nothing to stop being operational, this is just a waste of my time, I'm going to go to someone else. You don't want to be in that category. You'd rather be breach-worthy, like on Seinfeld, sponge-worthy. You want to be breach-worthy.
Brian, that's a T-shirt worthy quote. If I can ever heard one, I can tell you that. Maybe we'll create one for the next episode.
Breach-worthy, I like it.
And you alluded in your response. Talk to me about the ever-changing regulatory compliance environment, how it's affecting both the process of due diligence as well as potentially how companies respond to these breaches.
Great question. In terms of the process of due diligence, it's making it more important to do cyber diligence and to do it every time, because beyond just being a security risk, it's now a regulatory and compliance risk for almost every company out there. And the Department of Justice just provided guidance in the last year in which they've said we're going to essentially forgive compliance lapses for companies if the acquirer identifies them during the diligence phase or otherwise as they're acquiring this company and takes appropriate steps at that point, or at least they're going to be more amenable to forgiving them. Regulatory compliance in the cybersecurity area has gotten increasingly important, but it's gotten increasingly complex because depending on what sector you're in and how many states or countries you're in, you may have to comply with many different regimes. How do we deal with this? One, you gotta use a third party to do cyber diligence, even if you have a great. It's almost always a collaborative effort where we're working with people in-house who are quite good. But the courts have basically said in the Marriott litigation around the breach that if you acquire a company and that company ends up having a security incident, a class action can proceed against you based on the sole allegations that your diligence must not have been reasonable, because if you had been reasonable, you would have caught this instance. So what people have said after that case came out was, you know what? Let's use a third party to work with because we want to blame somebody else if this happens, even if we think we're really good at that. So that's in the diligence phase. In general, I think it means two things. If you have an incident, one, you do want to speak with outside counsel. You want to have an outside counsel on retainer or just someone who you're going to be able to reach out to that you trust, because it really has become impossible for a CISO to stay on top of all that on top of his day job or her day job. In addition, it's important that companies think about the principles that underlie these regulations and laws and cases, because where the law is today is not necessarily where it's going to be tomorrow. You can predict based on the facts if you have a lot of experience in this area, you can predict what a court is going to say to your facts in the future, even if there is no decision about it right now, even if there's no regulation on it now. So it's important to be able to consult with a lawyer who can take your existing facts and say, all right, while there's no law against that at this moment, you're going to be sued for it and you're going to settle that. And that's happened to me, for example. I did a diligence once where I told the client what this company is doing with data is technically compliant, but they will be sued. There'll be a class action. And ultimately there was, and ultimately it was settled for many millions of dollars. So I felt good that I had called that out in advance for the client.
Did you at least get the credit for it?
No, nobody's going to give me any credit, but I'll take it.
And it sounds like there's a lot of gray areas, right? As you mentioned specifically with Marriott, the definition of if you've done enough to protect the data or prevent for the breach, but who defines that? You are at the mercy of the folks at the court to interpret whether this was done or not, and that gray area causes quite a bit of grief because again, there's just a lot of room for interpretation, and it can go either way.
And when that happens, whenever you have a standard that can go either way, then the result is you're probably going to end up settling the case at some point. So you're probably going to end up spending millions to defend the case. And then when you get far enough that it's going to go to trial, you're either going to go to trial and take a big risk, but 99% of the cases are going to settle for some large sum of money in the millions. So you will have spent all this money. That's the challenge when you have a standard like this, because the standard is probably at the end of the day going to be, what would a reasonable acquirer have done at the time to assess the security of this company? And based on the information that reasonable company would have obtained, would they have done something differently? That's probably going to be the standard. But as you alluded to, David, there's going to be disagreement about that. There's going to be experts. Each side is going to hire experts, and they're going to present the opposite story. And so a judge or a jury or other fact finder, like an arbiter, is going to have to make that decision. most people aren't going to stick around for that. Most companies are going to settle it prior to that moment.
Brian, you've done a phenomenal job answering these completely unscripted questions and tackling. Some of those are tough to answer, and I didn't miss a beat. Let me ask you just one, maybe just final question. Current events, there was a settlement for Maersk for the cyber insurance, and I'm sure you have opinions. Specific. It took quite a few years to settle this, and some of the details were undisclosed, but it created quite a bit of waves in this, specifically cyber insurance industry. I'd like to get some feedback on that, if you don't mind.
Yeah, so you're talking about the war exclusion there?
Yes.
Yeah, so
correct.
my view on cyber insurance and how this should work is that cyber insurers are free to exclude anything they want to exclude. It's just a contract, after all. But they should be very transparent about what it is they're excluding so that the buyer can price that in when they're deciding whether to get this insurance or not. And in the case of the war exclusion, almost every kind of insurance policy that I've seen has some kind of war exclusion, which basically, even homeowners, if there's a big war between us and Russia or whatever country it may be,
You're on your own.
yeah, and everything in the U.S. gets destroyed from a nuclear weapon, we're not going to be able to afford to cover that for the whole. So we're excluding that. But I think, but at least until recently, and I haven't looked at recent policy language on this, but at least until recently, none of the war exclusions said anything about a cyber attack or a nation state attack that, or a attack on your infrastructure that happens to have been directed from a nation state. And to me, as a kind of reasonable person out there, I wouldn't assume that just because the actor that commits the crime is a nation state means the war exclusion applies. So I have generally agreed with courts who have interpreted those provisions in favor of the insured. Where a policy is ambiguous, it should be, in my view, and the view of most courts, it should be interpreted in favor of the insured, because at least in many situations, the insured was the smaller, less resourced party in the thing, and they don't really have the ability to negotiate most of the terms. It's usually take it or leave it. I personally think those decisions that found that are going in the right way. And I think it's going to be attribution is always an issue in any cyber attack. And you're probably, in most instances, or many instances at least, no one's going to have the resources to track it all the way down to be 100% certain who caused the attack. When I was with the DOJ, we did have the resources to do that. We could go for 10 years and identify people and prove it beyond a reasonable doubt. And we had to, because we're going after them criminally, we had to prove it beyond a reasonable doubt. So it's doable. But every time somebody gets a cyber attack, another company, they're not going to have the resources. They're not going to have the technical tools, the subpoenas, the search warrants, the mutual legal assistance treaty requests that we have in order to do that at the government level. So you're not going to know for sure who did it. And then even if you trace it back to a particular nation state actor, it's going to be pretty hard for you to prove whether they were doing that as part of their work duties or whether they were moonlighting. Because a lot of these guys, in some of the countries at least, they get paid a government salary for doing their government hacking. So they go home at night and try and do some hacking on their own to actually make some money. I think in general, having too much of the insurance regime or any other regime rely heavily on really solid attribution of who the bad guy was that did the attack is probably problematic. That's my thought in this area in general. Whether it was a good settlement or not even the lawyers are probably debating that.
Oh, I'm sure, and I'm sure that after so many years of in the legal process, I suspect they went out and grab a beer or some sort, because it took quite a. I'm sure they became good friends after the 6-7 years that it took. And lastly, I'll ask you this: is there a quote unquote insurance policy you can take on a transaction gone sour due because maybe due diligence. So you go there, you do all your due diligence, everything looks okay. You acquire the company, all of a sudden things just blow up, and it happened in the past. Would you be able to? And by the way, cyber insurance companies have really become much more smarter in terms of what to include and what to exclude, and I think the customers as well becoming more savvy. And again, from your description, always don't walk alone, meaning either ask a lawyer, somebody specialized in, or ask a broker, somebody specialized in. They're not trying to figure things out on your own. So this is also the case. But coming back to my original question, last one, is there such a thing of cyber insurance policy or policy that kind of protects the buyer and the seller from a transaction gone sour?
So there's two kinds of insurance policies that we mainly focus on when we're dealing with a cyber transaction or a transaction and we're focused on cyber. So the first, of course, is cyber insurance. The buyer, the seller has their own cyber insurance policy, hopefully. You need to look at that insurance and understand what it covers, how much coverage you have, and what will the impact of the transaction be on that policy. In most policies that I have seen, the policy is based on when the incident occurred. So if the incident occurred prior to the sale, when the policy was in effect, it would still cover after the acquisition. And then you're going to need often a new policy to cover incidents that occur after that. So the main thing that companies need to look to are the actual cyber insurance policies, and they need to understand the terms, whether it's going to carry over or whether it's not. I recently dealt with a situation where the insurance was based on when you discover the incident. So that's very different, and you have to do different things in that circumstance. The other kind of insurance that's relevant in deals, or most relevant in deals, is what we call rep and warranty insurance. And I had an instance relatively recently where the company thought that type of insurance was going to fully protect them from a cybersecurity standpoint. But rep and warranty insurance is relatively narrow, at least as I understand it. The main purpose of rep and warranty insurance is the seller typically makes some representations as part of the sale. Like a representation might be that they're not aware of any existing breaches or compromises in the system, as an example, or that they're in compliance with all appropriate applicable regulations. What the rep and warranty insurance does is, if those representations turn out to be false, and you probably get into a debate about knowingly false or just false, it may depend on the particular policy, then, and you have damages as a result of the false representation, then you may be able to recover up to the amount of the insurance policy. So you have that, but it's not covering typically all cyber risk, just misrepresentation. So you got to be careful that you understand what you're getting there and what you're not getting.
Yeah, it's amazing the nuances that are related to all of that. And again, we keep bringing this up, but just listening to you, you'd be in dire straits just trying to understand it on your own. And it's better to hire somebody like yourself or the company to help in that process, and not getting into an area where after the fact trying to figure things out, or you made a mistake that it will cost you quite a bit. It's better to have somebody that you can consult with prior to the transaction or prior to things going wrong.
Yeah, and you want to be able to have someone that you can say to a court or regulator, what else did you want me to do? Because I hired, in my case, the former DOJ cybercrime prosecutor and national coordinator for all the DOJ cybercrime prosecution, former regulator for the New York Attorney General's office, who does nothing all day but look due diligence on companies for cybersecurity and data privacy. And this still happened. What else do you want me to do, Mr. Regulator or Mr. Court? Because you want him to say, yeah, you're right. There's really nothing. And I don't say that just about myself, but the point is, you want to be able to show you were reasonable in your decision to hire competent expertise to handle the situation. And that's not just true for acquisitions, it's true across the board, but it's especially true in acquisitions because there's an expectation that acquirers are going to do appropriate diligence, and a lot of courts have held that.
Yeah, absolutely, Brian. And at some point where you're talking, I envision you dropping the mic and walking away.
Yeah.
I'd
have to drop the headset.
So last but not least, we deal with difficult topics. I always like to, if all possible, to end in a positive note, because cybersecurity professionals are always down in the weeds and everybody's so grumpy. But things are not, the sky is not falling and things are improving. And I would love to hear from you. What have you seen that can elevate our mood in terms of where things are going in the near future?
I'm always looking for those things too, David. So if you've got some for me, I'll take them too. I think we can all, based on the success of BetterHelp and these companies that do virtual online therapy, I think we all need some good news, and cybersecurity is certainly no different. But I guess if I had to pick one thing, awareness of the importance of cybersecurity is spreading. Like C-suite, CEOs, CFOs, COOs, boards of directors, audit committees are all beginning to recognize to a greater degree that this is really important. They need to understand it to some degree. They need to focus on it to some degree. They need to hire competent people to deal with it. It wasn't too long ago that you had a really hard time getting the board or the C-suite to care about any of these issues. CISOs weren't Section 16 officers who are like official officers of the company. And we're seeing a change in direction where people are actually recognizing the importance of cybersecurity and being willing to spend some money on it, even when there isn't an incident that's requiring them to. Are we there yet? No. And we may never be there fully. It may never be the number one issue on a non-cyber person's mind, at least until they get hit with it. But there has definitely been a positive trend in that direction. And even the regulations, we don't want to comply with them. We don't want to have to deal with 100 different regulations out there. But one could also see it as a positive sign that the regulators themselves also recognize now that cybersecurity is important and it's not some issue for some kid in his basement. It's actually something they should be thinking about as well. So even though we don't like dealing with the regulations, it's a good sign that people are recognizing this area is important.
So you made a lot of friends by making that statement right now. I can tell you that. And you're right. Things are going in the right direction, despite the fact that maybe not in the speed that everybody would like to. And I think that there's also awareness from individual consumers and people that are using technology from school age and above. So we're all in this together. That concludes the conversation today. Brian Levine, thank you very much for taking the time to chat with me. It's been a very insightful conversation, hopefully for all those who joined as well. And until next time, stay safe online as well as offline. And I'll see you.
All right. Catch me on LinkedIn, everybody. Take care.
Take care.
Bye.
Thank you.